of the Learned Director, I, on behalf of Sikkim Judicial Academy, would like to begin today's session on Interplay between POCSO Act 2012 and Juvenile Justice, Care and Protection of Children Act 2015. To conduct the session, we have with us Mr. Prajwal Khatiwada, Learned Registrar Judicial Service and OSD to Honorable the Chief Justice, High Court of Sikkim. I request Learned Director to kindly offer Khada to the Learned Resource Person. Thank you very much, sir. May I now request Learned Director to kindly give the welcome speech. Please, sir.
It is my pleasure and privilege to have the benign presence of today's resource person. We have come to the important topics of today's program. I, on behalf of Sikkim Judicial Academy, would like to welcome you, sir, to today's program. I equally would like to welcome the Learned Public Prosecutor, Additional Public Prosecutor and Assistant Public Prosecutor of Subordinate Courts. They have joined us to attend today's session. As far as the topic of today's program, in my opening remarks is concerned, that this there is a judgment of Hon'ble Supreme Court of India that Samriti Thakuram Bhakti versus State of Maharashtra. In that particular judgment, Hon'ble Supreme Court has given guidelines for recording the evidence of vulnerable witness in criminal matter 2022. And similarly, after judgment delivered in Nupun Saxena, recently on 30th June 2021, Honorable Supreme Court of India in SLP 7772 of 2021 has not warned but advised all subordinate special judges of across the country, including the Court of Judicial Magistrate, not to record the name of victims anywhere during the court proceeding. And the witness protection scheme has also come. And if we dig out the stakeholder of POCSO Act, there is no stakeholder of POCSO Act. We have to rely the stakeholder of JJ Act 2015 for lodging complaint, providing assistance for medical examination of victim, recording 164 statement, and even at the time of recording statement before the court, we have to rely the stakeholder of JJ Act. There is no stakeholder of POCSO Act. And at the same time now, there is a bonding issue. The Honorable Juvenile Justice Committee of Honorable Supreme Court is going to organize a national level consultation to find out the solution how to implement the POCSO Act. Now, POCSO Act has been now implemented from 2012. Several years already been passed. Now, Honorable Supreme Court, including the JJ Committee of Honorable Supreme Court of India, including the Sovereign Court, Honorable High Court, felt it that we are not able to implement the POCSO Act vis-a-vis JJ Act. And the main issue before now today we have to resolve is, now great challenge to all public prosecutors is now how to prove, how to bring your victim within the parameter of section 2D of POCSO Act. That is a great challenge. Until and unless you prove, then you cannot stay before the court supporting the case of prosecution, saying that this is my case, POCSO case, before a special judge. So with these particular words now, without further delay, I would like to request the knowledge resource person to kindly begin the session. Thank you so much.
And other attendees here. We recently had a similar program where Mr. Yadav was there. Ma'am, unte for Sada? No, Tarjan sir was there. Jyoti ma'am was not there. I think Mr. Pokhrel was there. And some police officers were also there. And I'm glad that in quick succession, NG sir, the learned director, has also fixed this program, which as on today is the most, I would say, because of rampant POCSO cases, where even juveniles are involved, and you see in all these cases, there is at different points, or I would say at every level, interplay between these two legislations, POCSO and Juvenile Justice Act of 2015. Earlier we had the 2005 Act, before that we had the 1986 Juvenile Justice Act. Now, before proceeding any further, I don't see the barracks with the learned participants. We can do one thing. Why you connect or thing screen ma try garnu यहीँबाट म वेबसाइटबाटै के प्रोभिजन देखाइदिन्छु if possible. Definition of child. Basic when we start under both the legislations, but normally we say legislation, but out of every legislations, in both these legislations, is there any similarity in the definition of child? They say, out of curiosity, I went through, I had gone through it earlier also, just to refresh your memory. First I will read out the definition of child under the POCSO Act. Section 2, subsection 1, clause D. Child means any person below the age of 18 years. I repeat, child means any person below the age of 18 years. Now I come to the definition of child under the Juvenile Justice Care and Protection of Children 2015 Act. In short, I will refer to as a Juvenile Justice Act of 2015. Please note, child under POCSO, child means any person below the age of 18 years. In Juvenile Justice Act, child would again mean, child means a person who has not completed 18 years of age. Can you make out the difference? Arjun sir, Jyoti ma'am. I know, that's what. So child, under POCSO Act, it says, any person below the age of 18 years. Under Juvenile Justice Care and Protection 2015 Act, it says, who has not completed 18 years of age. Who has not completed 18 years of age. So obviously, 18 वर्षों को if there is a child बनो, if he completes 18 years, then he becomes, how old?
90. After completing 18.
If he completes his 18 years, he becomes 30 years old. 19 to I don't know. For example, yeah. If I complete, after I am born, if I complete 1 year, I am 1 year old. So basically they mean the same. But the words, the way they have been used, I know Alikati, we are Alikati, taken aback, who has not completed 18 years of age and any person below the age of 18 years. Right? So the moment he is 18, he is not a child, either under POCSO or who has not completed the 18th year. 18th, so the 18th. No, you just academic. Now the moment any POCSO matter is reported, by the time the role of the public prosecutor and by the time, once your new face to me here, good name?
Sir,
Please be seated. You have Mr.
Judicial.
So you have PP of which court?
Sir, ABP Juvenile is
Acha, very good. Juvenile Justice Court.
recently.
This is the first time I am seeing you actually.
Yes, sir.
So let us do one thing. Since our director sir has also recently come back from North Sikkim, यता कृष्ण मैम बड़े हामीले के सबको इंट्रोडक्शन चाहिँ गरौँ so that each other बा भेट भएको छैन कि मैम बसेर मैम you're too formal मैम and which court so that I also know and sir also knows.
Hello. Good morning everyone. I am Assistant
Additional PP of Principal District Institution Court.
Good morning everyone. I am Jyoti Subba, PP of District and Sessions Court, Gangtok.
I'm Hishik Galson, Assistant PP in the Juvenile Justice Board, Gangtok.
Now we started with the definition of child. In case Krishna ma'am says you mistake. We started with the definition of child. Right? This is right. Be it a police station, be it before a child helpline center or juvenile welfare center, or if it is reported to a family member. Now let me tell you out of my personal experience as a judicial officer who has dealt with so many POCSO cases since 2013, it is very difficult for the victim and his or her family to actually report these matters in detail. Yeah. Matters in detail. It becomes very difficult. For example, if Falana came, is my uncle, in 60% cases or 70% cases, or even maybe 90% cases, the perpetrator is known to the victim or the child survivor. I will refer to the victim as child survivor. Now look at the efforts made by our superior courts, our constitutional courts. Trial court, of course, trying and punishing the culprit. But our constitutional courts, be it the high courts or the summit court, the apex court of the country, look at the effort, look at the sensitivity with which they have been dealing with POCSO matters or any case involving children. It could be a custody matter between parents or family members. It could be POCSO matters. It could be other matters relating to, it could be a simple domestic abuse case, domestic abuse of a minor. Just look at the sensitivity and what our learned director rightly pointed out, Nipul Saxena's case. So many orders have been passed in that case. And step by step our Hon'ble Supreme Court has actually, I would say, as our guiding angel or as our apex court has been showing us the way forward, the way ahead as to how, with what sensitivity are we to deal with such matters. Victim ko naam. In fact, let me tell you, in one of the first POCSO judgments, I must have shared with Yadavji and Tarjan sir, one of the first POCSO matters which in which I was writing the judgment, dictating the judgment, I dictated the name of the victim. I was in Namchi then. Then my stenographer said, "Arey sir, naam lekho na." And that was the first POCSO judgment in the state. 2012 Act came, and by the time the trial and all were over, 2013 my first POCSO judgment probably in the state, known judgment. I was dictating that judgment. He said, "Arey sir, naam lekho." I said, "Arey, it is in-camera proceedings. These are in-camera proceedings. No one is going to know." And in order to avoid confusion in future, it was a conviction matter, so obviously the party, the convict, would go on appeal. So I said, look, since it's an in-camera proceedings, no harm writing the name. He had cautioned me, the gentleman, Dichen had cautioned me. So no lekho. Are lekha na in camera proceedings. So okay. बहुत conviction हो. तैयार देखी quick success में और एक जोड़ा judgments बनी done. सबे में victim को नाम. I think 7 judgments, all convictions. The name of the victim was written. Now all these matters obviously went on appeal to the Hon'ble High Court. I believe all the 7 judgments were upheld because there is nothing much. Nani ko statement or medical evidence, and if they corroborate each other, it obviously is a conviction. Unless the case is of or extraneous considerations which are on the part of the prosecution. Otherwise, it's a 99% conviction case. So it was the Honorable High Court of Sikkim which was pleased to first point out that look, yes, conviction right, evidence appreciated, well appreciated, very good. But the learned trial judge ought not to have mentioned the name of the victim in the judgment. It started with that, okay fine. So after that judgment came, obviously the other judgments, in other conviction matters, even acquittal cases, names are completely stopped. Because that was the copy was sent to all the judicial officers in the state and probably to public prosecutors. Then that was at the level of the High Court. Then later on Supreme Court in few cases, passing remark which ought. But from this judgment, with reference to POCSO, with reference to POCSO, Nipun Saxena case, as Sir rightly pointed out, said enough is enough. Academically, I'll tell you, just like the childhood definition we started, section 228A, all these judgments refer to section 228A of the IPC 1860. Above, जति पनि judgments, even those judgments of the Honorable High Court, मेरो बड़ा ध्यान से नाम, all they would invariably refer to section 228 capital A of the IPC 1860. अब क्या हो ये चीज़? माथि गएर त पानी हराए जस्तो छ कि हेर्दा सर सेक्सन 228 capital A clear छ सर ज्योति मैम is it clear to you ma'am disclosure of identity of the victim of certain offences etc. Whoever prints or publishes the name or any matter which may make known the identity of any person against whom an offence under section 376, 376A, 376AB, so on and so forth, is alleged or found to have been committed hereinafter, etc., shall be punished with so and so, so and so. Then nothing make known the identity so and so shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. Nothing in this section extends to any printing or publication of the name Estesto if such printing and publication is by or under the order in writing of the officer in charge of the police station so and so, authorization in writing of the victim herself, which obviously in POCSO cases would not apply, then so and so, since explanation may have no. The printing or publication of the judgment of any high court, again at the very beginning I said constitutional courts, not the trial courts. We are trial courts, not the constitutional courts like the Hon'ble High Courts or the Hon'ble Summit Court. The printing or publication of the judgment of any High Court or the Supreme Court does not amount to an offence within the meaning of this section. ISMA, since senior PPs are also here and young PPs are also here, दुईटा चीज तपाईले काइन्डली नोट गर्नुहोस्. एउटा त सेक्सन 228A, everybody has been referring to that, but let me tell you, this section 228 is that learned APP त्यो IPC छ त्यसमा, त्यसमा सेक्सन 228 उसमा जानुहोस् त A मा IPC को त्यो कहिले इन्क्लुड गरेको छ एक्टमा कोडमा
83 सर.
हजुर
83 सर.
1983. अब एक त यो सेक्सन 228 83 मा आई होप यु आर करेक्टेड 83 मा गरेको सम एमेन्डमेन्ट एक्टले गर्दा 83 मा दिस पर्टिकुलर अर्थात् 228 चाहिँ ए गर्दा हैन. अर्को प्लिज लुक एट द ब्याकग्राउन्ड एन्ड देयर आर भेरी फ्यु पीपल विल टेल यु दिस in the country. I am not talking about Sikkim. This section 228 capital A has to be read keeping in mind or bearing in mind that it is a provision under the, firstly a procedural aspect has been put in the substantive law of the IPC. Very unique thing. IPC मा त substantive offence punishment हुन्छ नि त, यो definition, but a procedural aspect has been included here. Secondly, this came at a time when in-camera proceedings were either not known or very little known. बुझ्नुभयो नि तपाईले? This is purely an academic discussion. It came into the statute book at a time when either the concept of in-camera proceedings was not known or very little known. So obviously when we apply this provision that envisages a situation or is based on the premise that the proceedings are in open court. This is the background of this section. Ma'am, when this, are you getting my point, sir? Sir, good name, I'm so confused.
Sir, it's mistake.
Yes, sir, mistake. When 228 capital A came in the statute book, in camera POCSO obviously was not there. After 40 years or so, POCSO has come 2012. So it was in the backdrop of proceedings which were held in open court. But thanks to our constitutional courts, they have borrowed that provision, which open proceedings are मात्रै हुन्थ्यो, to even in-camera proceedings under POCSO or even Juvenile. Our litera scripta, if we go by the letter of the law, अरे कसरी apply गर्नु POCSO मा भन्ने हुन्थ्यो. But expanding beyond that and going through the underlying principle of this particular provision, the underpinnings of this provision, Manu, the Honorable Constitutional Courts have extended it to even child cases, even in-camera proceeding. So much is the, look at the intensity with which our Honorable Constitutional Courts have been guarding the identity of the victim. That is why when you as public prosecutors, and especially those associated with the magistrates court or those magistrates who have been exercising jurisdictions under section 164 or आजकल तो 164A के हम छ victim child victim को तो करना ही पड़ता है आजकल. Please ensure that obviously the application of the IO is pursuant to you. It is you who places the application of the IO for recording the statement of the victim before the learned magistrate, especially those who are in magistrate's court. So please ensure that identity minor victim so and so. अलिकति तपाईले बुझ्ने पाराले त्यो try and do that. The problem is अब आजकल त हुँदैन, Sikkim being a small place, all the judges and magistrates have already been well informed, are already well informed that okay, we are not supposed to disclose the identity. नभए तपाईले 3-4 years back को हेर्नु सबै 164 स्टेटमा नानीको नाम पनि हुन्छ, पेरेन्ट्सको नाम पनि हुन्छ, एज सबै हुन्छ. But trial and error गरेर हामीले over a period of time we have evolved to this particular आजको present situation where it is almost, the disclosure is almost nil. Another thing, 228A, back of the mind, applications of the IO, it could be for medical, even doctors here. Unfortunately in Sikkim, the medical assistance in any criminal matter is only half-baked. Why I say half-baked is, we have best of the doctors, we have best of the forensic experts. But unfortunately, Mr. Hisse would not be knowing, unfortunately Mr. Hisse, what they do is, of course they will attend to the child survivor at the moment they are brought to the hospital, PHC or wherever. No doubt they will take the swabs, take whatever, do whatever tests and all with their kits, medical kits and all, prescribed kits, sir. They will do with the best of the intentions, they will do it. And to the best of their ability, they do it. But while seal packing it, seal packing, maneuver thing, packing and sealing. Hon'ble Supreme Court says seal packing. While packing it and then sealing it, say, they are absolutely careless and they do not know that later on it is going to harm the prosecution case, for which tapaharule kasto mehnat garnu. So please make an impression on the PPs or the IOs also that look, you are going to collect the medical evidence. Please ensure that the medical or the biological जो पनि छ, it could be nails, body को जे पनि छ, blood, के अरे तपाईको vaginal swabहरु, vaginal washहरु, त्यो चाहिँ your constable or your special messenger जो पनि छ, accepts it only if it is properly sealed after being properly packed. Properly sealed packed भन्छ हामी चाहिँ. यो कुरा कहिले तपाईले at the very threshold याद राख्नुपर्छ. And please impress this upon the IOs who come to you the moment a case is registered. And I am told that in the coming days we will have public prosecutors or law officers attached to each police station, which is a very good thing. So please be prepared for that as well. Your identity thing, please don't take it lightly. Even public prosecutors, we have seen adverse comments against the public prosecutors for the manner in which, not in Sikkim, for the manner in which they prosecuted the accused, for the manner in which they have, I would say, for the casual manner in which they have introduced some evidence. The manner in which they have, the cavalier manner in which they have brought the opinion evidence of the expert. So as PPs, you are the bedrock or the main players in this whole criminal justice system. Yo kura tapaile, and this is why we need to be sensitive to all these things. Let me admit, while doing so many POCSO cases, I had lost that sensitivity. Oh, okay, POCSO case, of course, you obviously feel bad for a kid, but mechanical exercise. So even I had to be reminded, right? Who said people need to be reminded more than to be instructed? Someone had said that. So at times we lose that sensitivity. For example, Mr. Hisse may be dealing with 7 cases related to child abuse. It could be at the stage of opposing an application under section 167. For example, Mr. Hisse, Magistrate Court ma huncha tapai?
Sir, juvenile.
Juvenile Court ma huncha? Okay, section 12. अहिले section 12 हो नयाँ एक्टमा पनि बेलको 12 to 15 हो. As juveniles, आजकल त juveniles भन्दैन by the way, child in conflict law. As a child in conflict law, I am entitled to bail भन्यो. But the offence is horrible, horrendous crime, right? So in such cases, your sensitivity would come. Maybe you will have to oppose it, saying that no, first we'll see what was his mental level and what was the gradation of offence zones for आजकल, right? You stage, but just keep that in mind. So your nipun saksena चाहिँ, I am glad that NG sir pointed it out at the very beginning. इसको citation तपाईले लिए and it is available in your net मा पनि छ. Supreme Court को website मा पनि if you have the case number. But easiest way is 2000 यो दुईटा तपाईले नोट गरिदिनुस्. Manu, if you are a Manu Patra fan, you can I think the SEC fan and money go, and obviously यहीबाट AR को cross citations पाइहाल्नुहुन्छ. यो चाहिँ and there are many judgments. यो होइन कि खाली यसमा निपुण सक्सेनाको एउटै मात्रै छ. There are many other judgments, orders on procedural aspects, on substantive matters. So please make sure that you read, you go through all these judgments of Nipun Saxena case. Now moving further, we started with the basics. Difference in definition of child in the Juvenile Act, in the POCSO Act. Then we started with the identity of the victim, which is such a burning topic right now that Hon'ble Supreme Court had to intervene through these judgments. Then we also dealt with the IU and sensitivity of the PPs at the lower court levels, at the first, when the rubber meets the road, what is the main contact point, criminal justice system, sensitivity should be there. Then, talking about our juvenile and that interplay between the POCSO Act and the Juvenile Act, age of the victim. This particular topic, you will see that, okay, there was physical or sexual intercourse, but age proved by it. I think fast track court ma, normal 376 cases ma, basic defense consent हुन्छ या veracity उमेरमै ढाँटेको छ भने, if somebody has lied with regard to her age or her age is doubtful, then her whole evidence is shaky भन्ने कुरा हुन्छ. It cannot be reliable. It loses its credibility. That is why as public prosecutors, तपाईहरुले age को जो point छ, you will have to give your 100% to that. Otherwise, the whole the whole edifice of the case जो तपाईले build गर्नुहुन्छ will crumble. Now for that is के भयो भने till if the senior PPs may remember, till this particular judgment, and I was the first one to quote this judgment in Sikkim because it had recently come, and since it was Justice Kher's judgment, whom I had the good fortune of meeting in person, उहाँको judgment हुनाले I just went through it, and later it came empty. Next was the state of Haryana, 2013, Volume 7, SCC 263. I repeat, dear participants, Jarnail Singh versus State of Haryana, JARNAIL Singh versus State of Haryana, within brackets 2013, 7 SCC 263. I repeat, 2013, Volume 7, SCC 263. Now, this is a judgment by Division Bench. यहाँ नेटमा म तपाईलाई देखाउनु भन्दै थिएँ. Justice J.S. Kher was one of the Hon'ble judges, and for the first time, के हुन्थ्यो भने, I'll just give you a background first. In different states, including our state, नानीको जब when it came to not only नानीको, child survivor मात्रै हैन, prosecutrix, adult victim, 376 को या sexual abuse को victim भयो, उहाँहरुको जब पनि एज को कुरा हुन्थ्यो, there was no set pattern for that. Ma'am's court would, ma'am को कोर्टमा म्यामले would show birth certificate, Tarjan सरको कोर्टमा he would show तपाईको स्कुल को सर्टिफिकेट, ज्योति म्यामको, I'm just giving an example, ज्योति म्यामको कोर्टमा madam would show again आमा बाउको एफिडेभिट. हेर्नुस् है त. So for the first time, and look at their intelligence, when you are free, but I tend to digress कोही बेला, only my PPs would be knowing. Okay, I have become a PP or a senior PP, APP, but for me, I have become a judicial senior, I'm a judicial officer, so and so, and content हामी नहुने. Then in there, जहाँ पनि बस्यो, then in there, यसो गर्छु, nothing doing. So, Google मा जानुस्, Supreme Court of India लेख्नुस्, Supreme Court of India क्लिक गर्नुस्, लाइभ प्रोसिडिङ्स जानुस्, एउटा प्रोसिडिङ्स हेर्नुस्. अस्ति कहिले अक्टोबर हो कि सेप्टेम्बर एन्डदेखि 22 सेप्टेम्बर हो स्टेज चाहिँ, त्यहाँदेखि चाहिँ सुप्रिम कोर्टको कन्स्टिट्युसनल बेन्चको प्रोसिडिङ्सहरू लाइभ भएको छ. And they have beautifully maintained these archives also. So Yadav sir, for a person who used to deal, me, Tapai, Jyoti ma'am, for us who deal with 80 cases in a day, 80, 120 cases at times, 120 cases at a day, like Zimati in the Hon'ble High Court, चारवटा फाइल हेर्दा त अन्त बुझ्नु नि तपाईले, अब चारवटा एडमिनिस्ट्रेटिभ फाइल थियो पनि, मेबी सब थियो पे फिक्सेसन को के हुन्थ्यो. सो व्हाट डु यु डु अब डल भएर बस्नु उतै अब के रे, व्हाट इज दैट गेम, दैट कार्ड वाला गेम एन्ड दैट क्यान्डी क्रश, त्यो गेम पनि खेल्नु भएन होला. सो व्हाट आई हेभ बीन डुइङ इज वाचिङ ऑल दिस प्रोसिडिङ्स, preparing myself to know these constitutional points, the way a senior advocate in Supreme Court would argue, the way your Attorney General R. Venkata Ramani, Naya wala, K.K. Venugopal, Purana wala, your additional solicitors, in the way they have been arguing, our senior advocates, how they have been arguing in the Supreme Court. र सुरुमा लाग्छ, but once you get used to it, त्यस्तो अनोखै चिज पनि हैन रहेछ भन्ने हुन्छ. We can also do भन्ने हुन्छ. It's only because we are not familiar with that. The moment we become familiar with that, सजिलो हुन्छ. For example, if you send one of your staffers टु सिलिगुडी जब यो सौदाहरू फर्स्ट टाइम गएको सेकेन्ड टाइम गएको अत्तालिन्छ पर 6-7 खेप गयो एक्सपर्ट हुन्छ बिकज हि इज नाउ फेमिलियर विथ द्याट प्लेस law books including constitutional points, service matters, POCSO, juvenile, whatever topic under the sun. No error is something. The moment you delve into it, the moment you start going through it, first one no buzla. Earlier I have been reading few classic books here, which I missed as a student school man. First ko 2-3 page to buzda. Second time पढ्यो थर्ड टाइम पढ्दा बुझ्छ के हो भन्नु खोजेको छ सो तपाईहरु पनि when यो सेक्सन 228A को कुरा गरे मैले ज्योति म्याम I have not heard any resource person say this जो background and बुझ्यो but they are borrowed it भनिन्छ I have not seen any constitutional court judges talking about it from this angle यो तपाईले याद राख्नुपर्छ So, हामीले पनि not only propound गर्ने expound पनि गरौँ मजाले interpret गरेर यो हो एउटा अर्को example and I'll tell you why I'm giving this especially to our young Mr. Isse अनि child psychology भनेर हामीले कुरा गर्थ्यौं and Justice Altama Kabir's judgment that look age of 18 cannot be I think 2012 तिर होला age of 12 to 13 now. Judgment is Subramaniam Swamy versus Union of India. You can just Google it. Age of the juvenile cannot be below 18 years. One. He has spoken. The highest court, and he was the highest judicial officer of the country. I went through that judgment in 2014. Now, the judgment said, okay, the age of the juvenile, because of international law and because of our international obligation, cannot be brought down to below 18 years of age. And he was referring to the UNCRC, United Nations, by net आयो UNCRC. You know, sir, I'll tell you. The judgment said, God's text. I'll tell you two things. त्यसो गर्दा you realize. हेर्नुहोस् त. In that judgment, Subramanian Swamy versus Union of India, Justice Altama Kabir, who unfortunately is no more. I had the good fortune of meeting him while inaugurating Sikkim Judicial Academy in the High Court complex. He was the chief guest. He inaugurated it on 6th of June 2013, and I was the first director at that time. So in that judgment, in view of international obligations, and UN conventions, we cannot bring down the age of the child to below 18 years, 1 year, and that is the law. The academic, I told you in the beginning, academic discussions. Article 1 पढ्नुस् त म आइडेन्टिटी पढ्छु तपाईलाई हेर्नुस् त and nobody in the country will say this thing to you and the second thing which I am about to say article 1 जे bedrock of जसको फाउन्डेसन हाम्रो जुवेनाइल लॉ को फाउन्डेसन हाम्रो यो कन्सेप्ट को डेफिनेसन अफ चाइल्ड को फाउन्डेसन यही हो I will read it out article 1 of the United Nations Convention on Rights of Child 1989 यहाँ घडी राखेको छैन भाइ राख्नु पर्छ घडी It says हेर्नुस् त राम्रो सुन्नुस् है for the purpose of present convention A child means every human being below the age of 18 years. अब अगाडिको लाइन पढ्नुहोस्, unless under the law applicable to the child, majority is added earlier. Unless, I'll underline this, unless under the law applicable to the child, majority is added earlier. So does this mean that in view of our international obligation, age of a juvenile or a child in conflict with law should still be kept under 18 years? Are we bound by this? Absolutely not. Unless under the law applicable to the child, that means domestic legislation. Our parliament can come up with a domestic legislation saying that it can go down to 16. Because you only said at the first place that because of our international obligation, हामी सक्दैन चाहिँ गर्नु. But look at the text. Unless. So firstly, with all due respect, we are not bound by it. Or people said, and in the same judgment probably, yes, child, in view of their immature, in view of their not being able to fully comprehend and understand things, they are still to be regarded as child. Now, I pose this question to you. What about those cases in which there is accelerated mental growth of the child? For example, Mr. A's child, Mr. A is an IAS officer, or Mr. A is a public prosecutor. His child, properly casual, properly उद्योग हेर्चा भयो, राम्रो कम्पनीमा उद्योग भयो, र यता बिचारा एउटा स्लबमा a poor kid who is in association with डरलाग्दो रेपिस्टहरू who regard women as object of pleasure with त्यस्तो ग्रुपमा, watching pornographies, watching तपाईँको अब voyeurism, stalking गरिरहेको. So can you say that यहाँ जो हाम्रो IAS को जो kid and that kid who is in the wrong company, bad company, would have the same level of maturity? That is why there is a psychology book. I have that book. And this is also part of my dissertation in one of my masters. What about accelerated growth? Accelerated psychological growth or accelerated mental growth. You might food for thought, right? And because of all this, in US, Juvenile ko Mr. is saying, there is one article written by me. I'll somehow send you the text of that. Before our 2015 Act came, before this gradation of offense and your mental came, I had ordered for few books from the US through one person, my younger sister, on juvenile justice in UK and US. उता के सिस्टम थियो भने अब त्यहाँ त 10 वर्षको अब हिस्ट्री हेर्दा त 10 वर्षको नानीलाई पनि जेल हुन्थ्यो रहेछ त्यहाँ त युकेतिर त. युएसमा पनि 16 अब जुवेनाइल अब हाम्रो जस्तो एकदम उति छैन, ओभर सेन्सिटिभ इन दिस म्याटर्स. So there is something called gradation of offenses. Heर्नुस् है, in US also, in UK also, gradation of offenses. Then prosecutorial discretion. Prosecutorial discretion, gradation of offense. What is your gradation of offense? Badma 2015 they have incorporated that principle. 2015 Act. So in serious offenses, heinous offenses, their mental acuity हेर्नु के हेर्नुपर्छ हैन? हो This is a concept borrowed from the US and the UK. Gradation of offense. अर्को म त जहिले यादव सर कार्जन सरलाई जहिले भन्छु र अझै हाम्रो एकजना साथी हुन्थ्यो पोखरेल सर prosecutor in some of the states, probably in Haryana also, Directorate of Prosecution. र US मा डिस्ट्रिक्ट अटर्नी या जो यसरी पब्लिक प्रोसिक्युटर जो गर्नुहुन्छ प्रोसिक्युटर्सहरू, their word is almost final. You know, okay, this case, no, we have no evidence, no trial will lie in the police. इसको लागि why to prosecute? अलिक डरलाग्दो offense ल्याऊ, then we'll prosecute. That is called prosecutorial discretion. That is the power that you wield. So that is why, thanks to our director, thanks to our Honorable Chief Justice, thanks to Justice Bhaskar, for conceiving this program for the public prosecutors. And thanks to them for bringing me here. यो कुरा, यो जो दुईटा कुरा, हेर्नुहोस् है त, obligation त छैन नि, हैन? Jyoti ma'am, for a person with your intelligence, unless under the law applicable to charge, unless your discretion is there. And if you are a student of international law, I have written few articles on international law also, you will know that domestic legislation can be in line with international obligation, but there is no harm in domestic legislation being contradictory to the international legislation. For example, international conventions are domestic laws of the domestic law ne follow garnu paryo, you are bound by that. Eta in principle you are bound, eta ta by law you are bound. Ra yo duita kura, accelerated psychological growth, your definition of yo in the context of Justice Atlamas Kabir's judgment, and अघि मैले फर्स्टमा 228A को कुराहरु is something which you will very rarely hear. But I wanted to discuss it with you so that हाम्रो चाहिँ कोही कहिले के हुन्छ भने एकहोरे हामी जान्छौँ, suddenly oh yes, from that angle पनि हामी त्यो. So 228, look at the principle. यो कुराहरु तपाईले kindly याद राख्नुहोस्. Now नेट पनि आयो. जर्नलिस्टको हामी कुरा गर्दै थियौँ नि, जस्ट अ मिनट. मैले साइटेसन पनि दिइहालेँ. जर्नल सिंह. There are many General Singhs of huge here. Kher Saab ko judgment. Yes, Kher Saab ko judgment. Now, if you remember, dear participants, in the 2000 wala Act, Juvenile Justice Care and Protection of Children Act of 2000, not the 2015 one. And Yadav sir, Tarjan sir and myself, before Jyoti ma'am came, we have 100 times we have discussed this, right? Clearly, sir, Mr. AC, is it clear to you, ma'am? Rule 12. If you remember, under that 2000 Act, rules were also made. Though in those juvenile justice rules, for Rule 12 ma, यो कुरा लेखेको थियो, जो तपाईहरुले everyday follow गर्नुभयो. In every case concerning a child or a juvenile, pointer छैन, pointer. Vote of the board, as it is maybe the committee, child of the committee, referred to in Rule 19 of this rule shall determine the age of such child, within a period 30 days from the date अलिकति तल आउनुहोस्. In every case concerning a child, seeking evidence by obtaining matriculation and equivalent date of birth, birth certificate given by a corporation. अब तपाईले हेर्नुहोस्, which document has primacy, matriculation or equivalent certificate has primacy. The idea is by the time a kid, हामी पनि class 10 सम्म पुग्दाखेरि our age is, no one would normally lie about the age, and it's taken to be that age. You know the and in the absence whereof, Mr. is said, and in the absence whereof, the date of birth certificate from the school other than play school first attended. Very and in the absence whereof, which obviously means together we cannot take these documents. For example, if you have this document, birth certificate even given by a corporation, in our case, say, health department is. Now this document, pani cha ra yo document pani cha. Mr. said, this document won't have primacy over this document. You knew this. Journalism ko judgment ma chahi for the first time. Yo judgment ma chahi for the first time, jasko citation tapaile linu bhayo. Are, when we have been determining the age of the child in juvenile or child in conflict with law, with reference to that rule 12, the same principle can be adopted for determining the age of a child survivor. Above Mr. Issy, that law has gone. Now, kunche section ma cha naya act ko, Mr. Issy, since you have been doing juvenile matters. No, don't try my other dekha also. Then next time I think for no. इसमें तो अगले हेर्नुहोस् कि एकछिन सेक्सन 94 मा छ नयाँ एक्टमा सेक्सन 94 अब हेर्नुहोस् त अघि व्हाट वाज द फर्स्ट डकुमेन्ट व्हिच हैड प्राइमेसी अब के छ मिस्टर इज द डेट अफ बर्थ सर्टिफिकेट फ्रम द स्कूल or the अघि सेकेन्डमा के स्कूल फर्स्ट अटेन्डेड नट प्ले स्कूल बट हियर इट सेज डेट अफ बर्थ सर्टिफिकेट फ्रम द स्कूल यो डिफरेन्स तपाईले याद राख्नुहोस् है किनभने यो होल केस इज डिपेन्डेन्ट अन द एज अफ द विक्टिम or the fast track court and sessions trial is of the prosecutrix or the victim. यो तपाईले याद राख्नुहोस् र पोक्सो केसेसमा our high court or our Sikkim high court has given so many judgments under the POCSO act. Now I'll give you a mantra whereby if there is judgment of Madhya Pradesh High Court, Guwahati High Court and Sikkim High Court. हामीलाई त obviously Sikkim High Court को judgment पाउँछ unless there is a Supreme Court judgment saying अर्को चीज हैन. So what you should do is तपाईको सबमा आइफोन छँदैछ एउटा आज ज्योति म्याम कति तपाईले गर्नु भएको होला स्पेशली यङ वान्सहरुलाई इभन इफ यु आर इन नाम्ची और मंगन म्याम यो याद राख्नुस् है आर्गुमेन्टको दिन हुन्छ नि अब आजकल सिनप्सिस फाइल गर्नु भन्छ नथिङ डुइङ गुगलमा जानुहोस् हाई कोर्ट अफ सिक्किम लेख्नुहोस् क्लिक गर्नुहोस् हेर्नुहोस् है अहिले म स्टेप बाइ स्टेप भन्छु नोट नगर्नुहोस् वेबसाइटमा जानुहोस् फ्री टेक्स्ट स्पिच लेख्नुहुँदैछ एभ्रीवन टेल मी अनेस्टली मिस्टर हिस्से हेभ यु युज्ड इट टिल डेट सिनियर्सहरूलाई म सोध्दिनँ, यु हेभ नट युज इट। अब यसमा जानुहोस्, क्लिक। तपाईँको कोर्टमा के केस आर्बिट्रेसन छ, पोक्सोको एज डिटर्मिनेसन छ, एनी केस, एमएसिटी केस, अब जस्तो ब्लक डेभलपमेन्ट अफिसर कोर्स सर्टिफिकेटको बारेमा छ, सर्च आउँछ आउँछ। यत्रो जजमेन्ट्सहरू, and most of these are from my judgment. Age of victim. हेर्नुहोस् यो अहिले कस्तो जमाना आयो मिस्टर हिस्से, since you are a very young lawyer. Age of victim हेर्नुहोस्, तीनटा जजमेन्ट। There are others also. If I write POCSO त 100 वटा हुन्छ। नथिङ डुइङ, तपाईँको अघि जर्नल सिंह छ नि, जर्नल सिंह नि एन्टर गर्नुहोस् त। हाइकोर्टको अब एडिसीको जजमेन्टहरू पनि छ। यत्रो जजमेन्ट प्राय यो हाम्रै जजमेन्टहरू हो। देख्नु हुँदैछ Mr. Isse? Click any of those judgments on any topic. Let us say arbitration. मेरो छेउछाउको इसी चाहिँ पढाइदिनु पर्यो, जे पनि मेरो छेउको छ। हेर्नुहोस् त आर्बिट्रेसनको जजमेन्ट्स, हाम्रो सिनियर गभर्मेन्ट एडभोकेट्सहरूलाई काम लाग्छ। न किन चाहिँ मैले यो तपाईँहरूलाई यो लगेँ भने तपाईँको फर अल पोक्सो म्याटर्स, यो बिटविन साडा म्याटर्स, यादवसँग गर्नुहुँदैछ, फास्ट ट्र्याक म्याटर्स, इभन मेजिस्ट्रेटको 164 को हर टपिकमा you will find a judgment of our Hon'ble High Court. र invariably Hon'ble High Court को अलिक रिफाइन गर्दा पनि हुन्छ सर्च। जस्तो मैले सेक्सन 164 स्टेटमेन्ट गरेँ, आएन। रिफाइन इट के कीवर्ड्स हेरेर गुगलमा गरे जस्तै। हेर्नुहोस् त कतिवटा जजमेन्ट देखायो। सेक्सन 164 अभियसली 164 त अरू छैन, सिआरपिसीकै जजमेन्ट्सहरू मोस्टली छ। सो तपाईँहरूले भनेको होइन भाइ बन्द गरिदिनुहोस् आवाज, नट एट द कस्ट अफ अब पार्टिसिपेन्ट्स। whenever any POCSO matter तपाईँले डिल गर्नुहुन्छ and you are in search of, you are not able to lay a hands on any handy judgment to convince the judge or the concerned learned court, go to High Court ko website. Simple, I'll just repeat it for you. Will I close Garu? Google ma garu, click garu, अलिकति स्क्रॉल डाउन, अब मोबाइल में आके पार्ने आउँछ फेरि। किन चाहिँ आजकल चाहिँ कस्तो जमाना आयो मिस्टर हिस्से, it doesn't matter how intelligent a lawyer or a judge is, आजकल जमाना। What matters is how quickly and how efficiently he or she is able to lay his or her hands on the best of the authorities. Your defense lawyer may be not up to the mark, not up to the mark. Case तपाईको strong छ, but उसले case बिगारे पनि, but he is able to lay his hands on some of the best judgments. say. To turn the tables. ल यो चिज हामीले हमेसा वेदर यो भयो आई थिङ्क बार हेज बी प्रोभाइडेड विथ एससिसी भन्नुपर्नेहरू पनि छ बाररूममा होइन त्यो छ त्यसो गर्दा यो सबै फर पोक्सो अर एनी टपिक द्याट यु कम अक्रस वाट आई डु इज नर्मली जब पनि कुनै टपिक आउँछ फर्स्ट आई स्टार्ट विथ एसटिसी फर्स्ट चाहिँ एसटिसीहरू हेर्दिनँ फर्स्ट चाहिँ आई गो टु माई बुक्स अहिले 1 जुलाईदेखि चाहिँ बुक किनेको छु म कहिले अब के आउँछ कुरा बुक्सबाट हेऱ्यो आफ्नो बानी राख्यो 6-7 एउटै टपिकको लागि 6-7वटा बुक पढेर हेऱ्यो देन एसटिसी अझै रिफाइन देन म अनुपात्र आउँछु देन कति त एआर अनलाइन पनि छ विच इज मच चिपर एन्ड देन आफ्नो हाइकोर्टको साइटेसन तपाईँको केस वुड बी रक सलिड एन्ड यु आर नट प्रोसिक्युटिङ दि अक्युज ओन्ली फर द्याट ट्रायल कोर्ट डेली सोच्नु पऱ्यो तपाईँले अक्युज कन्भिक्सनमा पनि त सुप्रिम कोर्टसम्म जान्छ why would you stay in jail for 20 years without even trying up to the level of the Hon'ble Supreme Court and that too when he is getting free legally? So, तपाईँहरूको आर्गुमेन्ट चाहिँ त्यो ट्रायल कोर्टमा मात्रै होइन अनरेबल हाई कोर्ट तपाईँको केसमा मेजिस्ट्रेट कोर्टमा फर्स्ट अपिलेट कोर्ट सेकेन्ड अपिलेट कोर्ट सुप्रिम कोर्ट मन्त्र फर सक्सेस एन्ड मन्त्र फर इफेक्टिभ प्रोसिक्युसन यही अरू केही छैन नौ regarding section 94 Juvenile Singh our high court ko website ma je judgment cha we are absolutely clear age ko aune bitikai apply the same principle okay ra what we have seen is especially our PPs who have been with me they will tell you they will agree with me birth certificate of late चाहिँ हाल्नु थालेको थियो सर स्कुलको होइन स्कुल फर्स्ट एटेन्डेन्ट त्यो भए पनि ठिकै छ कल द प्रिन्सिपल लेट हिम कम विथ द ओरिजिनल डकुमेन्ट होइन एन्ड अदर डकुमेन्ट्स अल्सो यो होइन कि अदर डकुमेन्ट्स हेभ नो बेरिङ इट क्यान स्टिल बी रिलायड अन करोबरेटिभ एभिडेन्स यो तपाईँहरूले फर एज अ भिक्टिम याद राख्नु नाउ मुभिङ फर्दर एज पब्लिक प्रोसिक्युटर्स एज स्पेसल अब यहाँ हेर्नुहोस् है योर रोल इज नट ओन्ली एज पब्लिक प्रोसिक्युटर एन्ड हाम्रै हाइकोर्टको जजमेन्टमा अन्डर पोक्सो स्पेसल कोर्ट स्पेसल पब्लिक प्रोसिक्युटर दिस स्पेसल वर्ड दिस डिमान्ड्स मच मोर देन फ्रम ए रेगुलर द्याट इज वाइ चुनेर मात्रै स्पेसल पिपिसहरू बनाएको छ स्पेसल कोर्समा सो यु विल हेभ टु पुट इन एक्स्ट्रा एफर्ट विच यु हेभ अलरेडी डुइङ र एज भयो इन्भेस्टिगेसन सबै भयो एजको पनि तपाईँले पुरा थ्रेड बेर जानुहोस् के डकुमेन्ट छ के छ सबै विटनेसेस अब चाइल्ड विटनेस अब एक त तपाईँलाई सिचुएसन के आउँछ सिन्स ही अर सी द चाइल्ड सर्भाइभर इज प्रोन टु मेकिङ सम भेरिएसन्स इन स्टेटमेन्ट के हुन्छ भने आई गिभ यु एन इक्जाम्पल तपाईँले आज सपोज घर जानुभयो घरमा नानी छ तपाईँले जस्ट सोध्नुहोस् उसलाई नानी आज बिहानदेखि के गरेछ भन्नुहोस् त ए अङ्कल या पापा मम्मी बिहान आई वोक अप लेट एन्ड स्याटरडे छुट्टी हुन्छ स्कुलहरूको देन आई वाच दिस देन आई एट यस्तो देन आई प्लेड विथ माई फ्रेन्ड्स देन आई वाच्ड computer games, played computer games, and then you came. निम्ति प्यारेन्ट सोध्नु अब म्याडमको अर्को फ्यामिली मेम्बरले त्यही नानीलाई त्यही सोध्नुहोस् आफ्टर सम टाइम नानी के गर्यो हेर्नुहोस् he will say play today and he will skip few things obviously फेरि अझै हाफ एन आवर बाद अर्को फ्यामिली मेम्बर नानी के गरेछ कति के भन्नु हो बिहान यस्तो यस्तो भयो यस्तो यस्तो त्यहाँ एकछिन तपाईँहरू आइ त आज बेलुका फेरि 5th टाइम सोध्नुहोस् त 6th टाइम सोध्नुहोस् त केही गरिन भनिन्छ नानीहरूको साइकोलोजी हामी पनि त्यही हुन्छ सो इमेजिन 160 पुलिसले सोधिरहेको छ फेरि एक दुईवटा यो क्युरियस बिन्स हुन्छ होइन, उता के नानी के भयो तपाईँले त फर्स्टैमा गार्ड गर्नु पर्यो बेस्ट अफ द स्टेटमेन्ट 164 र 164A आउँदा एमेन्डमेन्ट जो भएर आएको छ, यहाँ यत्रो सिनियर पिपिज हुनुहुन्छ, टेल मी पहिला त मलाई भन्नुहोस् कतिवटा केसमा डिफरेन्टली एबल्ड स्पेसली एबल्ड भिक्टिम छ? यादवजी, तपाईँले पोक्सो केसेस जो गर्नुभयो बिफोर मुभिङ अन टु साडाको, कतिवटा केसमा डिसेबल्ड भिक्टिम थियो होला? 2. राजेनजी तपाईँ हुँदा 2, 3. ज्योति म्याम, तपाईँहरूले एज म्याजिस्ट्रेट्स कोर्टमा जुभेनाइल्समा हुँदा कतिवटा डिसेबल्ड भिक्टिम चाइल्ड सर्भाइभर अन्डर पोक्सो केस आउनुभयो? नन सो फार?
One presently, sir.
Now, my second query to you, उनीहरूको सबको 164 भयो,
So,
यता त भयो, अफिसले ट्रायल सेसन्समा आयो भने स्पेसलमा आयो कोर्टमा आयो भइसक्यो। अब स्पेसली एबल्ड नानी हो नि, कतिवटामा भिडियो रेकर्डिङमा 164 स्टेट? नाउ कम टु सेक्सन 164 तपाईँकोमा रहेछ। हेर्नुहोस् है, यो हामीले अब कोही कोही बेला इन प्लेन साइट हामीले बिर्सिन्छ। एन्ड आई टेल यू, चिफ जस्टिस अफ इन्डिया जस्टिस जीबी पटनायक साहबले एन्ड मैले पहिला भनेको पनि छु, आइएम श्योर यादवजी र टार्जन सरलाई त मैले भनेको पनि छु, जस्टिस जीबी पटनायक लर्डसिप एउटा ट्रेनिङ प्रोग्राम इन भोपाल नेशनल जुडिसियल एकाडेमीमा he said one thing which I convey to you. कुनै पनि तपाईँले एक्ट गर्नुहुँदैछ एज प्रोसिक्युटर्स या एज जजेस, अन्डर सम एक्ट यु आर डिलिङ विथ समथिङ, प्लिज मेक स्योर, अनि मलाई थाहा छ भनेर हुँदैन, प्लिज मेक स्योर यु रिड द्याट प्रोभिजन। तपाईँले 10 केप 100 केप पढेकै होला, तपाईँले 10 केप 100 केप पढेकै होला, तर फेरि पढ्नुहोस्। अब आई जस्ट टेक यु डाइरेक्टरसँग 5C ल्याउनु पर्ने। हेर्नुहोस् है, तपाईँले म देखाइदिइहाल्छु। सेक्सन कुन चाहिँ कुरा गर्दैछ हामी? अब हेर्नुहोस् है, none of us has been following this provision, especially at magisterial level. Recording of confessions and statements भयो, चाइल्ड नानीको गर्यो। अब यहाँ हेर्नुहोस् है, अलिक तल in cases punishable under section 354 सबै यस्तो sexual offences छ, shall record the statement of the person against whom such offence has been committed in the manner prescribed in section subsection 5 as soon as commission after the commission of the court, provided that if a person making the statement is temporarily or permanently mentally or physically disabled, the magistrate shall take such assistance of an interpreter or a special educator in recording the statement. Provided further, हेर्नुहोस् है, magistrate level को हेर्नुहोस्, provided further that if the person making the statement is temporarily or permanently mentally or physically disabled, the statement made by the person with the assistance of an interpreter or a special educator shall be, Mr. Isse, videograph. हामीले म 3 वर्ष थिएँ गान्तोक कोर्टमा, एउटा भिडियोग्राफ आएन। I told all the magistrates, अहिले चाहिँ ज्योति म्याम आएको छ भने आई डु नट नो दे आर सपोज टु भिडियोग्राफ इट। अब आई विल टेल यु किन चाहिँ भिडियोग्राफिङ जरुरी छ। उसको स्टेटमेन्ट नानीको कोहेरेन्ट त हुँदैन। नर्मल नानीको त मैले इक्जाम्पल दिएँ अघि, केही पनि भएन झर्को बाँधेर, बिकज अफ रिपिटेड रिलिभिङ द्याट ट्रमा अगेन एन्ड अगेन। स्पेसली एबल, यो त डिसेबल ल्याएको थियो तर आजकल हामी स्पेसली एबल भन्छौँ। स्पेसली एबल नानी या चाइल्ड सर्भाइभर जो हुन्छ, मेल फिमेल बोय गर्ल, किन चाहिँ यो तपाईँले रिकर्डिङ जरुरी भिडियो। अब मुनि हेर्नुहोस् त जस्तै अ स्टेटमेन्ट रिकर्डेड अन्डर क्लज ए, यो क्लज हो हजुर, यो सब क्लज ए भन्दा यो सबै आएन। अफ अ पर्सन चाइल्ड सर्भाइभर भन्नुहोस्, who is temporarily or permanently mentally or physically disabled shall be considered a statement in lieu of examination in chief। तपाईले examination chief गर्नु पर्दैन। POCSO केसेस ज्योति म्याडम हैन तार्दिन्छ र फास्ट ट्र्याक कोर्टमा पनि, यो त नानीको मात्रै हैन, एडल्ट भिक्टिम shall be considered a statement in lieu of examination in chief as specified in Instruments of Evidence Act। चिफै पर्दैन, नानी आयो या भिक्टिम आयो, इन क्यामेरा हुनु पर्यो, क्रस थ्रु कोर्ट। अब के प्रब्लम छ, भिडियोग्राफी गरिदिँदैन। होइन, अब उहाँहरू सुन्नु, द्याट वाज नट योर फल्ट। के भयो भने अब्भियसली दिस इज द फल्ट अफ द इन्टरनेट मिनिस्टर, विथ अल ड्यु रेस्पेक्ट होइन। उहाँहरूले अब पुरानो लटलाई चाहिँ मैले भनेको थिएँ तर आउँदै आएको थियो त्यस्तो। उहाँहरूले भिडियोग्राफी गर्दैन होइन। अब इट कुड बी अ म्याटर फर द Hon'ble High Court to pass some strictures against it, but what do the prosecutor do now? Since this has not been followed, precondition for treating it as examination has not been followed, obviously फेरि गर्नुपर्छ। हजुर, अनि त्यो त पोक्सोमै छ जस्तो लाग्यो नि, रिकर्डिङ हुनुपर्छ। होइन त्यो चाहिँ किन चाहिँ रिकर्ड पनि भएन, भिडियोग्राफ त आउट अफ क्वेसन। तर किन चाहिँ 164 त त्यसो गर्दा त्यो त इन लिउ अफ एक्जामिनेसन भएन, त्यो भिडियोग्राफ भएन। अब होइन त्यो त इट इज देयर इन द एक्ट, त सायद तपाईँले गर्नुपर्छ होला है म्याडम, एकखेप हेर्नुहोस्, गर्नुपर्छ। ज्योति म्याम इज सेइङ द्याट म्याम इज यु डन इट अल्सो, जस्ट गो थ्रु। यसमा एभिडेन्स एक्टमा पनि होला, त्यो सिआरपिसीमा पनि होला, एभिडेन्स एक्टमा छ। अब गर्नुपर्छ तपाईँ म्यामले एकखेप हेर्नुहोस्। त्यही भन् अघि जस्तै दिपी पट्टनायकको कुरा, कुनै पनि प्रोभिजन हेर्दा अब मैले पनि, अब मलाई थाहा छ गर्नुपर्छ तर कहाँ छ। जस्तो भिक्टिमको आइडेन्टिटी मैले तपाईँहरूलाई सेक्सन 228A को खोज्नुहोस् त भनेको भए सायद हामीले सिआरपिसी खोज्थ्यौँ होला, सायद एभिडेन्स आइपिसीमा छ त सोचेकै थिएन नि हामीले, त्यो त प्रोसिजरल एस्पेक्ट हो। त्यसो गर्दा आई थिङ्क बबितामा हेर्नुपर्छ गरेर के हुन्छ भने, इफ द प्रोसिक्युटर गिभ्स हिज अर हर बेस्ट, तपाईँको केस त त्यसमै हुने भयो। दुई तिनवटा स्टेटमेन्ट आइदियो भने त काम बिगारेको नबिगारेको चाल पाइहाल्छ। वी क्यानट अफकोर्स इमोसनली जानु भएन, तर इफ समबडी हेज डन समथिङ रङ, हाम्रो त पायस ड्युटी हो नि टु एन्स्योर द्याट भएको कुरा ल्याइदिने र कन्भिक्सन। द्याट इज अ प्रोसिक्युटरहरूको न, प्रोसिक्युटरले गरिदिनु भएन भने ट्रायलको त मिनिङै छैन। त्यो तपाईँले याद राख्नु, यु हेभ टु डु इट होला म्याम। ल त्यो गऱ्यो एट द कोर्ट में से नो वी हेभ नो टाइम, अरे and if the court proceeds without video recording, can file a revision against that order, you know. हाम्रो चाहिँ के मैले स्टेटमा देखेँ भने भेरी लेस अनरेबल हाइकोर्टमा जान्छ, फेरि त्यहाँबाट भेरी लेस सुप्रिम कोर्टमा जान्छ। त यो प्रोभिजन गऱ्यो भने चाहिँ अलिकति मेन्टल एक्सर्साइज पनि हुने, सबै एन्ड विल नो वाट इज वाट, होइन? त्यो तपाईँले याद राख्नुहोस्। देन यो स्टेटमेन्टको स्पेसली एबल्डको म्याम नर्थमा हाम्रो फ्री टाइम पनि हुन्छ अलिक, होइन? त प्लिज टेल उर्वशी म्याम भिडियो रेकर्डिङ चाहिँ हुनुपर्छ, भन्नुपर्छ, बिकज द आइयुज वुड नट बी डुइङ यु विल ह्याभ, किनभने एप्लिकेसन त फर्स्ट तपाईँले त्यही हेर्नुहुन्छ, म्याम यो म चढाउँ भनेर कुरा आउँछ, फर्स्ट त तपाईँले हेर्नु, यस यु क्यान फाइलिङ गर्नुहुन्छ, होइन? अझै यादव सरले त आफै फाइलिङ गरिदिनुहुन्थ्यो। त्यसो हुँदा इट इज योर रोल। द मोमेन्ट अ पुलिस अफिसर comes into contact with the victim and later on with the accused, they have to contact you. अब त विटनेसेस चाहिँ अब तपाईँले डिस्टेन्सै राखेर हाम्रो नभए हिजो अस्ति म्याडमले तल बोलाउनु भएको थियो, सरले तल बोलाउनु भएको थियो, तपाईँलाई नै एम्बेरेसमेन्ट हुन्छ ल। यो कुरा अर्को तपाईँले याद राख्नुपर्छ। र अब रेकर्डिङहरू एक दुईवटा तपाईँले अब भेरिएसन्स, जो मैले भेरिएसन्सको कुरा गरेँ, म तपाईँहरूलाई अब डिएनएको कुरा हुन्छ। अब कतिवटा केसमा चार्जसिट हेज बिन फाइल, तपाईँको सिचुएसन, मिस्टर हिस्सेको सिचुएसनमा एउटा भनिदिन्छु, जुभेनाइल बोर्डमै चाइल्ड इन कन्फ्लिक्ट विथ ल सेक्सुअल अफेन्समा आयो, he has been apprehended, I won't use the word arrested, he has been apprehended and has been sent to the juvenile observation home. 60 days passed. Within those 60 days or 90 days as the case may be, charge sheet filed but without the expert's opinion report. So firstly my question to Mr. Hisse is it a complete charge sheet? Which obviously is no. And can the accused claim, accused in your case child in conflict with law, claim default bail on the ground that within 60 or 90 days the full charge sheet, complete charge sheet has not been filed? How do you deal with that situation? No, I'll tell you. Supplementary मात्रै file गर्नु छ, expert opinion report मात्रै छ. It could be a drug case. Any case 167 to सबैमा राख्छ. So you can always, you have the right and it's your duty to oppose it as the case may be. होइन? Oppose गरेर, अरे bail has been filed, supplementary त, that doesn't mean that he is entitled to that default bail. And there are many rulings on that. यो एउटा कुरा तपाईले याद राख्नु पर्यो. अर्को, I was talking about DNA. A problem के आउँछ स्पेशली पोक्सो कोर्ट्समा, ज्योति म्याम, टार्गेट सर एन्ड इभन फास्ट ट्र्याक म्यामले हेर्नुहुन्छ, म्यामहरूले पनि उसमा हुन्छ, चार्जसिट फाइलको डिएनए रिपोर्टै आएन. र हाम्रो के भयो भने पहिला आई टेल यु, सायद ज्योति म्याडमको कोर्टमा, ज्योति खड्का म्याडमको कोर्टमा यो केस थियो, बलबहादुर छेत्री, स्टेट अफ सिक्किम वर्सेस बलबहादुर छेत्री भन्थ्यो. त उहाँले के गर्नुभयो, छिटो ट्रायल गर्नुभयो, कन्भिक्सन भयो, म्याटर वेन्ट अन. जस्टिस अग्निहोत्री सर, चिफ साहब, चिफ जस्टिस वाज देयर. ही सेड अरे डिएनए, बादमा त डिएनए नेगेटिभ आइदियो फेरि हो. त दिस जजमेन्टमा म तपाईँलाई, आई वोन्ट टेक यु थ्रु दि लेन्थ एन्ड ब्रेथ अफ इट. यो चाहिँ राख्नुहोस् कि टी चाहिँ बलबहादुर छेत्री वर्सेस स्टेट अफ सिक्किम. तपाईँले हेर्नुहोस् 2017 सिआरएल चाहिँ 1279. यो चाहिँ साइटेसन तपाईँको लाइब्रेरीमा इजी हुने चाहिँ यो छ, हाम्रो सिक्किम हाइकोर्टकै जजमेन्ट. यसमा द कोर्ट अट टु हेभ वेटेड फर दि डिएनए रिपोर्ट भनेर, त्यही भनेर हाम्रो 2-3 डिएनएमा पेन्डिङ छ नि. र कतिवटा सुप्रिम कोर्टको जजमेन्ट पनि छ, एउटा मेरो डेटाबेसमा पाइन्छ कि यो यो तपाईहरुले याद राख्नु पर्यो एज प्रोसिक्युटर्स किनभने बादमा तपाईहरु केस विक भन्नु नो योर अनर I think we'll have to wait for DNA report. Take sir in the meantime. Deserving case of an interim bail in stringent conditions. After the victim and the victim influence got the answer to situation. But this particular judgment, तपाईले नोट गर्नुपर्छ उदाहरण चाहिँ र अघि हाइकोर्टको वेबसाइटमा तपाईले खाली DNA रिपोर्ट हेर्नुस् यो जजमेन्ट आइहाल्छ है यो अर्को कुरा तपाईले याद राख्नुपर्छ देन Now, 164 record garnubha. To the best of the ability, learned magistrate has recorded the 164 statement. अब के हुन्छ भने statement variation 0 हुन्छ. Notice report variables. Ends. On consent प्रायः तपाईलाई आइडिया छँदैछ र एक दुईवटा पेकुलियरिटिजको चाहिँ आई जस्ट पोइन्ट इट आउट टु यु व्हिच केम ह्यान्डी when I was in the court. Consent of victim where no alarm or disclosure but only after pregnancy. Mostly youth involved भएको केसमा हुन्छ अब यो त प्रोसिक्युटरले त लाग्दैन अहिले त एक्विटलको हो हैन किन पछि प्रेग्नेन्ट हुँदा मात्रै भने बट एज क्राइटेरिया इज इफ द एज इज लेसर बिलो 18 then it is an offense. अब के छ भने few high courts, few honorable high courts such as the Tripura High Court, Calcutta High Court, there are some judgments which say that अरे केटा पनि young छ केटी पनि young छ how can it be an offense under POCSO though she might have been भनेर भनेको छ अब के हुन्छ भने आई विल टेल यु माई ओन एक्सपिरियन्स हाई कोर्ट्सहरुको जजमेन्ट इन द टिथ अफ सुप्रिम कोर्ट जजमेन्ट अब Hon'ble Supreme Court has in many judgments said look law is law एज अफ डिस्क्रिप्सन को कुरा हुँदैन offense is offense but these two high courts, Tripura and Calcutta, Machi, I have a young keta-keti affair case. So what I would advise you is, academic matter you can discuss. Moi pani bhannu parle no hunta buta ani ani lekidinchu. Are POCSO is what? Protection of children from sexual offences. Now if two adolescents, I know, teens bhannu, they come together, there is some contact. Is there abuse or offense against each other? Where is the intention? मै हो भने बुटा हामी लेखिदिन्छु तर अब छोटीको परिवार पनि भएन कि त आफू त्यस्तै पोजिसनमा हुनु पर्यो सो इन प्रिन्सिपल आई एग्री विथ दोज टु तर when it comes to you as prosecutors हामीले फेरि अरू सुप्रिम कोर्टको एक दुईवटा No, an offense is offense. Justice Loku Saabko judgment, Madan B. Loku Saabko judgment. Below 18 means POCSO. यो तपाईले याद राख्नुपर्छ अब कतिवटा सिचुएसन भेरी रेयर सिचुएसन अन्डर पोक्सो चाहिँ अफेन्स भयो अन्डर हिन्दू म्यारेज एक्ट चाहिँ बिलो 18 हो भने voidable marriage नट इभन void marriage voidable marriage भनिएको छ अब what do you do? बुझ्नुभयो नि मिस्टर इसे बुझ्नुभयो you have read Hindu Marriage Act off late पढ्नु भएको छ पढ्नु in the Hindu Marriage Act and not many some of the personal laws below 18 लाई बिहा गर्यो straight away void हुँदैन voidable हुन्छ voidable at the option of the minor who may consent to it after 18 years भनेर हुन्छ these are the texts of the Hindu Marriage Act अब tell me अहिले a Hindu 21-year-old male marries a 16-year-old female अब के भयो भने under personal law त voidable भनिदिएको छ, पर्सी अफेन्स त भनेको छैन. But under POCSO and Justice Lokur's judgment, offense मात्रै judgment दिन्छु तपाईलाई. अब how do you prosecute in such cases? Obviously, I'll tell you the answer. Obviously, you'll have to go back to Supreme Court judgment, and this later act, which came while that Hindu Marriage Act is still in force. So an exception has been carved out. तो अब चाहिँ यही माइनरलाई बिहा गर्यो र हिन्दू म्यारेज एक्टले मलाई बचाए भन्नु मिल्दैन. यो तपाईहरुले पोइन्ट याद राख्नुपर्छ. म छिटो जजमेन्ट पाइहाल्छु. जजमेन्ट 75 एक्सेप्सन 2 मा जानुस् त.
For sexual acts by a man with his own wife, the wife not being under 15 years of age is not rape.
So that means if she is 15 years or 16 years or 17 years, is not rape.
Yes.
So this particular judgment, जो म तपाईलाई भन्छु, note गर्नुस् for your academic interest. Independent thought versus Union of India and others. I repeat, independent thought. अब स्क्रिनमा छ अगर तपाईले क्लियर देख्नुहुन्छ. Independent thought versus Union of India and others. र यसमा लोकुर साहबको जजमेन्ट हो. I again had the good fortune of visiting North Sikkim with him. AR 2017 SC 4904. AIR 2017 SC 4904. SCC पनि छ. हाम्रो बारको लाइब्रेरीमा SCC छन् नि. 2017 SCC 800. यसमा Justice Lokur is the author of the judgment. He has said that POCSO is POCSO. If below 18 years, no question of any exception arises. म अपरेटिभ पार्ट पढिदिन्छु किनभने and that exception has been set aside also. बुझ्नुभयो मिस्टर हिस्से? In view of the above discussion, I am clearly of the opinion that exception to section 375 IPC, insofar as it relates to a girl child below 18 years, is liable to be struck down on the following grounds. It is arbitrary, capricious, whimsical and violative of the rights of the child, girl child, and not fair, just, reasonable and therefore violative of Article so and so. It is discriminatory and violative of Article 14. It is inconsistent with the provisions of POCSO, which must prevail. So obviously that Hindu Marriage Act को voidable option, यही exception 2 मा चाहिँ which must prevail. त्यो हिन्दू म्यारेज एक्टको चाहिँ मैले तपाईलाई हाइपोथेटिकल सिचुएसन भनेको. दिस विल अप्लाई. इट मस्ट प्रिभेल. इट्स नट ओन्ली अ लेटर एक्ट बट अन अ स्पेसिफिक पोइन्ट रिगार्डिङ चिल्ड्रेन. यो तपाईले याद राख्नुपर्छ. इट्स अ भेरी गुड जजमेन्ट. लोकुर साहबको जजमेन्ट्स आर भेरी गुड. यु शुड इफेक्ट अल द जजमेन्ट्स आर गुड. तपाईले त्यो पनि हेर्नुपर्छ. देन यो कुरा पनि तपाईले अलिकति कन्ट्राडिक्टरी आयो भने तपाईले यो उसमा राख्दा हुन्छ. देन अदर देन द्याट द प्रोसिजरल डेलीको त मैले त्यति मेन्सन गर्नु परेन. जजमेन्टहरुमा पनि भयो. प्लिज मेक स्योर द्याट तपाईको रिटर्न सिनोप्सिसहरुमा भिक्टिमको उसमा अफेन्डिङ उठ्न नआओस्. र अर्को हामीले बिचमा यादव सर, तार्जन सर र मैले ज्योति म्याम आउनुभन्दा पहिला एउटा उत्यो पनि थालेको क्वेसनर सेक्सुअल अफेन्स इला लेट्स से एउटा 1990s लेट 1990s नै होला कि शीला वर्षे म्याडमले पुरा पिआइएलहरू फाइल गर्नु भएको छ एन्ड सी स्टिल एक्टिभ होला।
Where the court has taken up the position of striking down the provisions, the exception part. So would it stand, sir, given that the striking out would be a legislative power, not a judicial?
No. Ultra vires the very,
Yes, sir.
it's a Supreme Court.
Yes, sir.
Constitution ko sentinel,
Yes, sir.
तो almost Supreme Court ho.
Yes, sir.
So it may be section 66A jaste ho. It may have been written in the statute book, but with no purpose. The next time amend garda it will be deleted.
Yes, sir.
Because adding a provision and deleting a provision is a legislative, you rightly pointed out. It is still in the statute book.
Okay.
So based on that judgment, our next coil kunche session ma one of the MPs will have to move it.
Yes, sir.
I know.
If it does not go forward, sir, then the judgment.
No, it's OTS, redundant. You can just ignore it.
Yes.
No?
Yes.
Good thought. I understood तपाईको जो background बाट मैले बुझिहालेँ question को background बाटै त्यो त section 66A capital A भने जस्तै नि. So if you buy a new Bear Act,
Yes.
it will say struck down in so and so judgment. ल म त्यो क्वेश्चनहरुको तपाईलाई देखाउँ भन्दै थिएँ कि anyways give me one more minute कि त्यसमा पनि पाइन भने चाहिँ म verbally भन्छु तपाईलाई. यसमा children's home को बारेमा कुनै केको बारेमा. So one of त्यस्तो cases was victim of त्यतिबेला त पोक्सो थिएन यो 90s को कुरा. Prosecutrix rape cases मा डाइरेक्ट चाहिँ अब यो इन्टिमिडेटिङ क्वेश्चनिङ हुँदैन बाइ डिफेन्स काउन्सिल र क्वेश्चनर एउटा प्रोभाइड गरोस् भनेपछि त्यतिबेलै बेस्ड अन अ प्ली बेस्ड अन अ पिएल Hon'ble Supreme Court ordered that. We followed in some cases, questionnaire, draft questionnaire provided, draft question provided. Then I think POCSO happened, other judgments, subsequent judgments and now recent judgments would also mention that. POCSO it must have been incorporated. A questionnaire should be provided for the judge. And the cross-exam through the court letter, that is it. And the aggressive question, and you as an officer of the court, apart from being a public prosecutor, is also an officer of the court. So when you oppose government, how can you? I mean, got a senior human nature, senior advocate, so they are, and they are also very gentle in these matters. But about your mutual understanding by the law over the government. So as public prosecutor, the defense might be a senior advocate. But the way you are, I think this is not permissible. Senior advocate also has to put questions to the court. And where is the questionnaire? We have not been provided with any questionnaire. तपाईले यदि तंग गर्नु भयो भने बादमा हल्ला पनि भइहाल्छ त्यहाँदेखि तपाईले उसको कोर्टमा चाहिँ पढेर जानुपर्छ प्रोसिक्युटर विल ग्रिल अस भन्ने हुन्छ यो तपाईले याद राख्नु पर्यो र क्वेश्चनर प्लिज मेक श्योर देयर इज नो डाइरेक्ट क्वेश्चन जस्तो एक दुई के आन्सर डीपी शर्मा सरले डोन्ट टेल नानी यस्तो भएन भन्थ्यो नानी हो भन्थ्यो यस्तो हुँदैन डीपी सर राम्रोसँग सोध्नुहोस् उसले त हो नै भन्छ नि हैन देन अगेन वी आस्क हिम टु रिफ्रेश इट र मैले पनि रिफ्रेश गर्थे नानी हो भन्दै त्यो हो भने त्यो त भएन नि उहाँले छिटछिटो बोल्नुहुन्छ नि नभन्नुहोस् न उहाँले त त्यो पनि तपाईले याद राख्नु पर्यो अरु बिफोर स्पेशल प्रोटेक्टिभ सेक्सुअल हेरेसमेन्ट डेफिनेसन तपाईलाई थाहै छ बोथ अन्डर आईपीसी कतिवटा फेरि सेक्सुअल हेरेसमेन्टको डेफिनेसन अन्डर आईपीसी एन्ड अन्डर पोक्सो एक्ट मा भेरी है फेरि कति अन्त मैले भनेको जस्टिस डीबी पट्टनायक प्रोभिजन एकीकृत सिमिलरै होला जस्तो लाग्छ अघि 228 पनि सुरुमा त हटि देखे मैले भरे त मुनि रहेछ त्यस्तो हुन्छ So provision बेयर एक्ट आजकल त अनलाइन पनि आइहाल्छ. प्लिज मेक श्योर. एउटा मैले अनलाइन सुप्रिम कोर्टको जजमेन्ट पढ्दै थिएँ अन्डर ड्रग्स एन्ड कस्मेटिक्स एक्ट. लङ टाइम ब्याक. त्यसमा अनलाइन सुप्रिम कोर्टको खालि 2 प्याराग्राफको जजमेन्ट थियो. के जजमेन्ट थियो भने इट सिम्स द लर्नेड हाई कोर्ट जज has missed the word and in falana section of Drugs and Cosmetics Act. We accordingly set aside the conviction and remand the matter, remand the appeal for fresh consideration by the High Court. Do you like? Bushdomani. It seems the learned High Court judge has missed the word and in section so and so, after the word so and before the word so and so. We accordingly set aside the conviction appeal and remit the appeal back to the High Court. Second appeal gakola tha. Remit the second appeal to only sorry SAP ma gakola to the High Court for fresh consideration and decision. Now it is very embarrassing for everybody. Section of के हुन्छ हामीले एन्ड को बेला पढ्दैनौँ. अर्को रिसेन्ट पोक्सो जजमेन्ट अफ जस्टिस माहेश्वरी साहबको जजमेन्ट अर्डरमा he is sentenced to undergo rigorous imprisonment for a period of 3 years and pay a fine of ₹10,000. In default to pay the amount of fine, he shall undergo further rigorous imprisonment for a period of 6 months. Is this sentence correct, Mr. Isse? Rigorous imprisonment, default मा rigorous imprisonment हुँदैन. Default मा चाहिँ simple हुन्छ. But अब ठुलो लेभलमा मिस्टेक हुँदो रहेछ. I don't understand. It's in the statute book, not judgment website मा छ. But we can choose to ignore it. र जहाँ पनि हेर्नुहोस् imprisonment of either description for a period of 3 years. How do you interpret this? Suppose Mr. Isse has to say, look, he has committed a terrible offense, horrendous crime. Or imprisonment for a term, for either term which may extend to 3 years. The imprisonment of either term, either description भनेको चाहिँ rigorous या simple भनेको. कति हामी कन्फ्युज हुन्छ either description के को description. त्यो either description भनेको चाहिँ प्राय आइपिसी मा तपाईहरुले हेर्नुस् of either description imprisonment of either description for a term which may extend to 7 years and fine. र description अगर त्यो choice दिएको छ भने it's up to you to play for rigorous child abuser and fine भन्नुभयो in default कोर्टले अगर rigorous भन्दैछ भने tell them look default मा rigorous हुँदैन default मा simple मात्रै हुन्छ एक नम्बर अर्को default cannot run concurrently. Default has to run if he fails to pay the fine will run only after the main of punishments of 3 years plus 6 months default. It can't be 3 years में concurrently. यो पनि तपाईले पोक्सो हैन त्यो सबै म्याटरमा एप्लिकेबल हुन्छ. त्यो बद्यान अरु I did not go statement of victim को पनि हामीले कुरा गर्यौं. Definition of sexual assault जान्नु परेन. Penetrative assault, sexual assault सबै उठ्यो भयो. तपाईको procedure for reporting of offense, you are experts in this. Abatement of offense कति त सर म्यामहरुले ज्योति म्यामले ट्राई पनि गर्नुहुँदैछ. Then recording of statement भइहाल्यो. Additional provision statement to be recorded. यो सब पनि हामीले गर्नु परेन. Failure to report, you all know. Designation sports, special courts, no problem. Special recording for trial to be conducted in camera. यो तपाईले याद राख्नुपर्छ र भइ पनि राखेको छ. Then compensation, though the prosecutor को उसको domain मा त आउँदैन, but as an officer of the court, you can always tell the court that some amount of compensation could also be ordered भनेर भनिदिनु भयो भने it would only be हैन some solace to the victim त्यो भयो. Then अरु त त्यस्तो केही छैन. हजुर.
The main thing required to be proved in a POCSO case is the first victim.
Child survivor.
And this is where we are falling short here because what happens is like I wanted to know whether the document जुन चाहिँ फाइल गरेको हुन्छ. So like for example they file a matriculation certificate. Now the defense, what they put question is like who entered the details. Now we cannot bring the regarding matriculation the company halcha. In POCSO mostly school records. So like the principal comes with the attendance register, then he says everything, then the defense puts the question like who had come? Did you make the entries yourself? So the entries mostly are not done by the principal, because there is another staff who does the entry.
Maybe that time your staff would
So they are long since retired and all. So that is where we are going. Is it mandatory that the person himself should come who has made those entries? Is it very like detrimental to the prosecution case if we do not examine those witnesses, because it is like possibly like not possible for us to bring those witnesses?
And Ismaji, how I would respond to it is by saying at the very beginning that you will have to make a foolproof case. I'll tell you. Obviously the principal, the then principal or the then headmaster, normally headmaster हुन्छ किनभने class 1 the primary school हुन्छ, the headmaster or headmistress जो पनि हुन्छ, they might not be available as of today. And obviously the person who has entered those they would also not be available. फलाना हाम्रो पिउन थियो, हाम्रो फलाना स्टाफ थियो त भन्नु साह्रै छ. So अलिकति यहाँ चाहिँ तपाईले what you have to do is convince the court. If that is not, if they can be brought, why not? Prosecutorले चाहिँ under 311 petition file गर्नु त कोही रोक त छैन नि. And if the court rejects their higher forum, you can approach them. र तर हेरेर यो होइन फेरि ब्याकफायर पनि नहोस्, भरे बोलाउनु भयो म त होइन भन्दैन, एम्बेरेसमेन्ट हुन्छ. त सिन्स इन भ्यू अफ द्याट सिचुएसन लेट द पेरेन्ट्स अल्सो सी हो. अन्त हाम्रो लेडिसिपकै जजमेन्ट छ कि पेरेन्ट्स एन्ड लेडिसिप इज ग्ल्यान्ड महादेव शर्माज जजमेन्ट, यो सबै तपाईले त्यसमा जर्नल सिंह लेख्नु भयो भने त्यो महादेवहरू सबै त्यसमै छ. पेरेन्ट्सकै एभिडेन्स इज द बेस्ट एभिडेन्स भनेको छ. बट सिम्प्लिसिटी त्यो मात्रै होइन फेरि, अन्त त्यो करोबोरेटिङ भन्छ हामी. जस्तो फर इक्जाम्पल अलिकति डाइग्रेस गर्छु, स्टेटमेन्ट अफ को अक्युज्ड, सेक्सन 30 अफ एभिडेन्स एक्ट, सेक्सन 30 अफ एभिडेन्स एक्ट, स्टेटमेन्ट अफ को अक्युज्ड हु इज बिन जोइन्टली ट्राइड, कन्डिसन इज जोइन्ट ट्रायल हुनुपर्छ. र त्यो स्टेटमेन्ट अफ अक्युज चाहिँ कस्तो भने म्याम, को अक्युज चाहिँ पहिला सबै केस प्रुभ भयो, त्यसमा थप मात्रै विथ अर विदाउट द्याट केही फरकै नपऱ्यो, त्यो फाउन्डेसन चाहिँ हुनु पऱ्यो नि त. तपाईँको केसमा यो केसमा इट्स अ भेरी कमन प्रब्लम. प्रिन्सिपल कम्स विथ द रेजिस्टर, he is not the same principal, obviously the same staffer is not, he is retired, he is deceased. How you त्यसो गर्दा चाहिँ एउटा तपाईले जस्टिस भास्करको एक दुईवटा जजमेन्ट छ जहाँ प्रिजम्पसनको कुरा हुन्छ, प्रिजम्पसन अफ भ्यालिड एन्ट्री, प्रिजम्पसन नर्मल रुटिन कोर्समा आउँछ प्रिजम्पसन. एलोङ विथ दिस प्रिजम्पसन तपाईको बादमा हेल्थ डिपार्टमेन्टबाट या पिएचसीबाट पनि त निकालेको छ थप, अघि सुरुमै जो भने करोबोरेटिङ प्लस पेरेन्ट्सको करोबोरेटिङ. त यो गरेर यु विल ह्याभ टु नो प्रोसिक्युटर, वाट आई टेल यु, हेर्नुहोस् कोर्टको एम हुनुपर्छ स्पिडी ट्रायल, प्रोसिक्युटरको एम हुनुपर्छ कम्प्रिहेन्सिभ, तपाईँको सबै छ, इट सुड बी यो विटनेस अल्छी होइन फेरि मान्दैन आउनु मान्दैन भेट्दैन न ट्राई गर्नु, डकेटली यु विल ह्याभ टु ट्राई द्याट. र डिफेन्सले त सानो रुपियाँ खोजिदिने हाल्छ. त यो केसमा चाहिँ म्याडम अब इच केसको आफ्नै मेरिट्समा म्यामले हेरेर, यु नेभर नो त यो स्टाफ छ, रिइक्जामिनेसन कतिजना हाम्रो पिपी साहबले रिइक्जामिनेसन गर्नु भएको छ. आफ्टर if it comes into cross-examination that हो त्यो स्टाफ त कोर्टमा छ, सरी यो त फलाना मिस्टर न्युपानीले गरेको एन्ट्री भन्नु. आफ्टर द cross-examination complete, you can may I re-examine him भने on one point, is Mr. न्युपानी still working भनेर तपाईँले सोधे भने उहाँले आन्सर गर्छ file 311 petition. अनि यो त फेरि त ल्याबको नाम त कुरा आउँदैन, दिस ट्रायल इज स्टिल अन्डर प्रोसेस. त सार्प माइन्ड, अघि मैले भनिहालेँ सार्प माइन्ड पनि रिसर्च केस क्लोज गरे भने त एनी कोर्ट वुड, नो कोर्ट वुड से एकखेप चाण्डक साहबले त्यो दिल हसन अन्सारीको केसमा ट्रायल सक्ने बेलामा 200 जना अझै ल्याउँछु भन्नुभयो, टाइम पास गर्नु नि, टाइम पास गर्नु. म सिजिएम त त्यति बेला आई रिजेक्टेड इट. पुलिस मान्छे रहेछ भनेर ट्रायल सकेको आफ्टर 6 years of trial चाहिँ he files a petition under section 311 praying for summoning 200 more investors. And उनीहरूको डकुमेन्ट छ, इट्स नट अन रेकर्ड, उनीहरूको केही छ, नट अन रेकर्ड. हेभ दे बिन क्लेमिङ, आर दे दि कम्प्लेन्ट्स? नो. मान्छे डम रहेछ भने he went on appeal and Justice Wangbi upheld the order and he state did not go to the Supreme Court. बुझ्नु म्याम? त्यो पाराले what witnesses are actually wanting, who should be summoned, who should be examined, who should be dropped, जस्तो अफलेट तपाईँले गर्नुहुन्थ्यो. सर he is being repetitive. एउटै कुरा भन्ने हो, उनीहरूसँगै ग्रुपमा हुँदै थियो, दुईटा गर्नुभयो भने एन्ड दि अदर पार्टी हेज नो सिरियस क्रसमा ल्याएको छैन भने वाइ सुड यु, तपाईँकै टाइम पनि वेस्ट हुन्छ. यु हेभ टु प्रिपेयर फर अदर केसेस अल्सो. त यो पनि तपाईँले याद राख्नु पर्यो. सो इन सच केसेसमा डिपेन्डिङ अपन फ्याक्ट्स एन्ड सर्कमस्टान्सेस अफ इच केस, बट योर एम सुड बी टु मेक अ फुल प्रुफ केस. त्यो तपाईँले गर्नु. Any other queries before we proceed further?
One more last query.
Yes, sir. Why last?
Actually, this is a request also. So if sir has any judgments regarding in cases where the victims have turned hostile, but yet the honorable senior courts have convicted the accused. If sir knows of any such cases, because mostly what we are facing is like other witnesses are there, all the witnesses except for the victim herself are supporting the case. So it's like that. Mostly we are facing that problem.
Victim herself,
she becomes hostile, but the other witnesses are there. For example, the doctor is there, the doctor's evidence is there. She gives the history herself. Then अरू पनि हुन्छ, but she herself becomes hostile. So if there is anything in these lines.
एक त मैम, if the medical evidence is there, you have declared the victim of a hostile to online or a child handler, but you decide to cross-examine her because she is showing the propensity to help the accused. Maybe आजकल तो फकाउँछ नि के गर्छ तर्साउँछ हैन. Prosecutors initially turning hostile, but they had judgment chocolate. अच्छा, मैं पढ़ना से स्क्रीन में था कि PW सुप्रीम कोर्ट को जजमेंट र यसको अर्को चीज पनि छ जो एकेडेमिक पोइन्टबाट म तपाईलाई भन्छु. PW1 prosecutors had initially not supported the prosecution case and was declared hostile. यो त एडल्ट victim को केसमा, but on being confronted with a statement recorded under section 161 र हाम्रो 164 भन्नु, she narrated the true and correct story and the manner in which rape was committed or not. अब यहाँ चाहिँ उले फेरि उल्टा भनेछ. She has categorically deposed यस्तो. अब नर्मली हाम्रो केसमा चाहिँ दे से दैट भन्नु त भनेको थिए तर ढाँटेको थिए भनिदिन्छ. मेजिस्ट्रेट सर म्याडमको अगाडि भनेको त थिए तर मैले ढाँटेको थिए भन्छ. अब त्यो केसमा म्याडम एउटा कसको थियो, त्यो एउटा केसमा के भयो भने हस्बेन्ड र वाइफ थियो, वाइफलाई आई स्टिल से मार्यो स्ट्र्याङ्गुलेट गरेर, वाक्यमको केस थियो र डेड बडीलाई झुन्डायो. हेर्नुहोस् है त, गर्जबी राई भन्ने केस हो. त्यसमा यु वन्ट बिलिभ होइन नलेख्नु त्यसमा सबै विटनेस हस्टाइल भयो तर मैले फर सम रिजन यो चाहिँ होइन बिकज हायर्ड बोन पुरा रिसर्च पनि गरेँ त्यतिखेर सरी हुन्थेन हायर्ड बोन चाहिँ यस्तो हुन्छ मेडिकल उसमा प्रोसिक्युटर्सहरूलाई म भनिदिइरहेको छु नर्मली सुसाइड कमिट गरेको हो भने चाहिँ हायर्ड बोन भाँचेको हुन्छ इफ इट इज नट अ सुसाइड केस स्ट्रेङ्गुलेसन मात्रै हो या त्यो हो भने चाहिँ हायर्ड बोन इन्ट्याक्ट हुन्छ इन द्याट केस चाहिँ दो ही claimed suicide, hired bone was intact, but it was going against him, that particular situation. Plus, अरू एभ्री घरको एउटा सानो नानी थियो उनीहरूको नानी केटी ल्याएको टिन्समा इन 14-15 एजमा उसले पनि 160 गर्दै थियो आई कुड नट अब बेयर अपन माइसेल्फ टु एक्विट हिम कन्भिक्सन भयो तर डिभिजन बेन्चले एक्विटेड भयो माथि के चाहिँ म्यामले इन सच केसेस गर्न सक्नुहुन्छ अब भिक्टिम हस्टाइल भयो 164 सम्म तपाईँले ट्याक्टफुली थ्रु द कोर्ट गर्नुहोस् कन्फर्म गरेर कति म्याक्सिमम तपाईँले एक्सट्र्याक्ट गर्न सक्नुहुन्छ मेडिकल एभिडेन्समा छ खोस्रेको छ प्राइभेट पार्ट्समा के छ DNA पनि पोजिटिभ होला सो इट्स एनीबडीज गेस द्याट इट्स अ केस अफ कन्भिक्सन तपाईँको लेभलमा चाहिँ कोर्टलाई तपाईँले कन्भिन्स गरेर गराउनुहोस् इट इज ब्रेभ हि अर सी इज अ ब्रेभ जज विल डु द्याट लेट दि कन्स्टिट्युसनल कोर्ट्स डिसाइड बट योर केस सुड बी फुल जस्तो गर्लफ्रेन्ड बोयफ्रेन्ड छ मेडिकल एभिडेन्स केही छैन अब त्यसमा पनि मेहनत त किन गर्नु हस्टाइल बट एकदमै चाइल्ड अब्युज केटा इज 38 इयर्स नानी इज 14 इयर्स त्यो हामीले एउटा बेलमा कोट गरेको थियौँ जजमेन्ट छ जस्टिस चन्द्रचूडकै जजमेन्ट छ हजुर
by the biological father and her own pupa. And the victim, she is a 7-year-old child who has been tutored so well. She comes and she lied straight on the face. एकदमै मजाले उसले अरू सबै कुरा भन्यो, but she lied because she could not even identify how I came to know that okay उ चाहिँ ढाँटे उसले चाहिँ यो ढाँटेको रहेछ भन्दा चाहिँ she didn't identify her own father also. So in such cases it just goes against our conscience. It will just sit in our conscience that it is a matter of एकदमै hostile यो त उसलाई ट्युटर गरेकै हो भनेर चाहिँ I know it very well. So
म्याम त्यसै गरी त यसो these situations can be अब हस्टाइल भयो द्याट टु त्यस्तो एक्सपर्ट पार्टी हस्टाइल भयो भने यसमा म सानो मलाई एउटा इन्सिडेन्ट तपाईँले भन्दै गर्दा 2005 मा एन्डी सर 2005 मा जस्टिस एसबी सिन्हालाई आई मेट इन भोपाल त मैले लर्डसिप हि ह्याड जस्ट रिटायर्ड एज सुप्रिम कोर्ट जज मैले लर्डसिप यो इन दिस केसेस वेन जुभेनाइल त्यतिखेर जुभेनाइल भन्थ्यो juvenile split cases. Now in the main case they are convicted, main accused. But in the juvenile court they are acquitted. No, this again seems contradictory. So asked to just asked to what can you do? We don't know. Achha to udhar ko lago. It could have been vice versa. Juvenile ma conviction to bhandaina hola record guilty hunthyo eta tapaile acquitted. तब each case has to be decided. अब त्यसमा यस्तो हस्टाइल छ भने but if there is overwhelming medical evidence, try गर्नुहोस् न म्याडम यसो नि unless we try on these points. हायर कोर्ट्सले पनि त त्यस्तो केसेस जाँदै गएन भने but यो इनिशियली टर्निङ हस्टाइल यसको लिइहाल्नुहोस् जजमेन्ट. This will come handy for all the prosecutors. स्क्रिनमा पनि छ हेर्नुहोस्. वाहिद खान versus State of Madhya Pradesh, 2010 to SCC 19. और इसको बाद में यही जजमेंट में रिलाई गर्नु यो चाहिँ फाउन्डेसन जस्तो भयो यसमा रिलाई गरेर मेनी जजमेंट द मोमेन्ट यू टाइप दिस तपाईको अरू जजमेन्टले देखाइहाल्छ। म्याम क्लियर छ म्याम? 2010 to SCC 9. त्यही अझै एक जोडा इनिसियली ट्रेनिङ हस्टाइल, कोही बेला चाहिँ सुरुमा हस्टाइल अगेन्स्ट एज भन्छौँ नि हामी, तपाईँलाई त्यति बेला काम हुन्छ। एक चाहिँ सुप्रिम कोर्ट जजमेन्ट त्यो भयो। अरू लास्ट फ्यु 2-3 जजमेन्ट्स दिइहाल्छु। स्पर्मेटोजोआ म्याम यो त अब तपाईँलाई थाहै छ, स्टेट अफ यसमा टिआई रेट यस्तो भिन्न absence of dead or mobile spermatozoa in the vagina or in the cervix of the prosecutor held not a conclusive proof in case तपाईँलाई चाहिन्छ भने ND absence of spermatozoa मा यो जजमेन्ट गर्दा आउँछ 2000 volume 1 SCC 247 ल। सिन्स यहाँ मेरो डेटाबेसबाट आइहाल्यो। कि नर्मली लुगाहरूमा भेजाइनल वासमा पाएको हुँदैन होइन, मेबी फर सम रिजन। त त्यसो गर्दा यो यिनीहरू कोट गर्नुभयो भने इट विल ओन्ली एड टु यो थियो। चाइल्ड विटनेस सोलहरू पनि म जानु परेन, देयर आर मेनी जजमेन्ट्स हाम्रो हाइकोर्टको, त्यो पनि तपाईँले हेर्नुहोस्। डिएनए So before we wrap up, any point, POCSO ko basically, madam, compensation aspect we need not go, but you can urge the court compensation under POCSO rules also, under section 357, 57A, sabai madam tapaile garda huncha. So anything before we wrap up, any well, yes, Mr. Sir.
So if it's not an issue, sir, if you could kindly go back to the definition of child, sir.
Acha. Okay. अच्छा, you were not there at that time?
So
अच्छा, I म verbally भन्छु।
Yes, sir.
No, it's basically अलिकति word मात्रै हुँदै हो कि सर। Under the POCSO, you will see that the definition of child is, I'll read it also. Child means any person below the age of 18 years. राम्रो सुन्नुहोस् है। Child means any person below the age of 18 years. Juvenile Justice Act ma child is a person who has not completed his 18th year of age. Would you mind, is there any difference in that? A child who has not completed his 18 years of age, the moment a child crosses the 18th year, कति पुग्छ हो?
18 to 19, running 18.
लेख्नु चाहिँ कति लेख्छ त? 18 नै लेख्छ नि। So the moment he is 18, he is not a child. Basically they mean the same thing. बुझ्नुभयो नि? वर्ड्स मात्रै डिफरेन्स छ र यो पनि मैले भनिहालेँ। जुभेनाइलको वी रेड आर्टिकल 1 अफ UNCRC र जस्टिस अल्तमस कवि, त्यो सबै चाहिँ एकाडेमिक हो कि। प्लिज डोन्ट कोट मी एनीवे, दिज आर प्योरली एकाडेमिक। जस्तो यो वहीद खानको जजमेन्ट लेख्नुभयो नि, यसमा ब्याड एक्ट, ही डिड ब्याड एक्ट्स विथ मी भन्दा रेपमा कन्भिक्सन भएको छ। अब्भियसली सी मेन्ट रेप भनेको छ, तर रिसेन्ट हाम्रै अनबल हाइकोर्टको जजमेन्टमा इज कन्ट्राडिक्ट। सो दिस जजमेन्ट वाज नट कोटेड बिफोर दि लर्निङ डिभिजन बेन्च। कसको फेलिङ हो? दि कन्सर्न पब्लिक प्रोसिक्युटर होइन, माथि को हुन्छ पब्लिक प्रोसिक्युटर? इदर दि एजिज अर जोइ त हो जत होइन, दे सुड ह्याभ पोइन्टेड इट आउट। अब के हुन्छ भने परिगुरेको कुरा हुन्छ, के कुरा हुन्छ, हामीलाई जानु पर्छ। बट त्यो वहीद खानकै जजमेन्टमा इसने गंदा काम कियामा रेप कन्भिक्सन। That is why a prosecutor, defense will always take advantage, and he or she, the defense is always would always stand to gain any minor loophole तपाईहरु। र यो सबै गर्छ अलिकति केसेसहरु लिगल टर्म्स भन्छ हामी, प्रलाग्दो प्रिपेयर गरेर गर्नु भने फुल प्रुफ केस, भिडियो रेकर्डिङ पनि सिरियसमा ल। एन्ड राइट, अब ज्योति म्याम भन्छ अहिले त ट्रायलमा पनि रहेछ, सबैहरु टु द टी तपाईले फलो गर्नु पर्यो। So I think that's it. Anybody else?
So one
Yes, Jyoti ma'am.
So, no, so the last
हजुर हजुर
त्यसमा सर फर्स्ट स्कुल एटेन्डेन्ट इज नट now no longer required.
Exactly.
Just the school attendance certificate is required.
हजुर
So that would be covered by section 94.
94
Yes.
now by section 94
Because त्यति बेला सरले भन्नुभयो and I thought that sir provided us with some judgments.
हजुर
Tried, went through all this but I couldn't find any.
ए त्यसमा छैन
That time
अनि यो त
I-
नयाँ ल हो त्यसो गर्दा
मैले-
नयाँ ल हो बट हाम्रो हाइकोर्टकै रिसेन्ट जजमेन्ट छ म्याडम सेक्सन 94 जुभेनाइल मात्रै लेख्नुहोस् कि हाम्रो हाइकोर्टकै एउटा जजमेन्ट छ किनभने त्यो जर्नल सिंह भयो जो हाम्रो हाइकोर्टको कोर्ट गर्यो हामीले त्यो चाहिँ बिफोर अन्डर द प्रिभियस एक्ट रुल 12 मा थियो त्यति बेला म्याम जुभेनाइल रुल्सको अब चाहिँ सेक्सन 94 मा आयो सो द न्यू जजमेन्ट्स विल रिफर टु 94
If I tried with section 94.
अहिले ट्राई गरिहाल्नु त्यो चाहिँ गरिदिनुहोस् ल हाइकोर्टको छ जस्तो लाग्यो न सुप्रिम कोर्टको त भइहाल्छ सर सक्यो सर यति सर सक्यो that it is imperative to establish the age of the victim and thereby her minority. Section 94 of the हेर्नुहोस् पहिला हाम्रै हाइकोर्टले रुल 12 गर्दै थियो because that was before 2015 को एक्ट यस्तो यस्तो हो provides for determination of age of the child in conflict with law and the child in यस्तो यस्तो although the victim is neither nevertheless the same parameters can be although the victim is neither nevertheless the same parameters can be utilized for purpose of determining the proper grounds to be married यस्तो यस्तो उनीहरूले चाहिँ रुल 12 गर्दैछन् बट नाउ यु हेभ द जजमेन्ट अफ आवर ओन हाइकोर्ट जसमा 94 को कुरा छ बुझ्नु म्याम यो जजमेन्ट नोट गरिहाल्नुहोस् न हेर्नुहोस् त फ्री टेक्स्ट स्पिचले आई डिडन्ट नो द्याट दिस जजमेन्ट वाज देयर बट थ्याङ्क्स टु यु म्याम एन्ड थ्याङ्क्स टु आवर वेबसाइट यो जजमेन्ट 2021 को सरी कहिलेको जजमेन्ट सेप्टेम्बर 2021 को जजमेन्ट आई वाज अनअवेयर अफ दिस द्याट इज वाइ त्यो फ्री टेक्स्ट स्पिच तपाईँहरूले चलाउनुपर्छ लेडिसिपको जजमेन्ट हो लेडिसिपकै जजमेन्ट हो सो द्याट्स इट ज्योति म्याम आई थिङ्क वी क्यान अब होइन उयो गरौँ एनजी सर थ्याङ्क यू भेरी मच वन्स अगेन फर गिभिङ मी दिस अपर्च्युनिटी सर एन्ड अरू पनि के छ माई फोन नम्बर तपाईँहरूलाई कतिलाई थाहा छ यु क्यान जस्ट नोट इट डाउन 94748 37940 I repeat 94748 37940 यसमा तपाईले टेक्स्ट गरेर कुनै ल पोइन्टहरु छ भने सिन्स आई एम नट प्रिसाइडिङ इन एनी कोर्ट नाउ फर सम टाइम नाउ त्यसो गर्दा एज रजिस्ट्रार जुडिशियल सर्भिस एन्ड एज वान अफ द फ्रिक्वेन्ट रिसोर्स पर्सन सेन्ट टु एनजी सर एन्ड हिज टिम फ्रिक्वेन्टली वी क्यान अलवेज डिस्कस फ्यु लिगल पोइन्ट्सहरु छ भने अन एनी टपिक दिल्लीबाट म अघि तपाईलाई भने सुप्रिम कोर्ट प्रोसिडिङ्स आई हेभ बीन वाचिङ यु वोन्ट बिलिभ 3-4 advocates, young advocates who are seen on the screen are all my classmates. त्यसमा डेली देख्छ डेली 3-4 जना देख्छ यङ्गर अब 40s वालाहरु चाहिँ दे विल बी असिस्टिङ द सिनियर्स र आफै बोल्छ एउटा त नबोल्ने मान्छे छ हि आर्ग्युज अमोल चितले भन्ने छ मेरै क्लासमेट हो पनि हि इज देयर एभ्री डे फेरि कोर्ट नम्बर 2-3 मा हुँदो रहेछ जहिले पनि सो बोल्दै नबोल्ने इज फ्रम महाराष्ट्र married to Pragya Bagel जो पर मेरे क्लासमेट हो both are my classmates 3-4 जना अहिलेसम्म मेरे क्लासमेट्सहरु चाहिँ त्यहाँ आर्ग्यु गरिरहेको छ आई वाज थिंकिङ अरे जुडिशियल अफिसर नभए त त्यहाँ हुन्थ्यो जस्तो म उनीहरुसँगै त हुँदै त कहाँ हुन्थ्यो सर हैन त्यसो गर्दा यो चाहिँ तपाईको सबै हामीले उयो गर्नुपर्छ एन्ड किन मैले त्यो कुरा गरेँ दे कल मी एट टाइम्स यस्तो यस्तो छ किन ट्रायल कोर्टको उनीहरुलाई आइडिया हुँदैन अरे ये बतायो भने हिन्दीमै पठाउँछ हेर्नुहोस् त हेर्न आई टेल के आफ्नो क्लासमेटलाई एडभाइस पायो त यो नम्बरमा पनि स्पेशली मिस्टर हिस्से यु एनी इश्यूज अन ल पोइन्ट्स जस्ट टेक्स्ट मी आई डोन्ट रिटर्न कल्स बट आई टेक्स्ट एकदम ल सो आई थिङ्क एनी सर द्याट्स इट राइट सर लाइक डिस्कनेक्ट गरिदिनुहोस्
We have come to the end of today's session. I would request Learning Director to kindly propose the vote of thanks.
Now we have come to the end of today's session. It is my honor and privilege to conclude this program by extending vote of thanks to all present here, especially the learned resource person who, keeping aside of all comfort and convenience, has been kind enough to accept our invitation and come here to deliberate on an important topic of today's program. By digging out all intricate issues involved on both acts in a very simple and lucid manner, for which I, on behalf of Sikkim Judicial Academy, would like to offer sincere thanks to our learned resource persons for his remarkable and wonderful contribution made to our learning participants. I equally would like to offer my sincere thanks to all learned public prosecutors, additional public prosecutors, assistant public prosecutors who, keeping aside of judicial work of paramount importance on board, without hesitation, come here and participated in this program and enhance the elegance with distinct presence. I, on behalf of Sikkim Judicial Academy, once again offer my sincere thanks to all of you. And lastly, I must offer my sincere thanks to entire team of Sikkim Judicial Academy, photographer who have captured the entire session of today's program, and GT Enterprise Catering Services for their support and cooperation throughout the program, for making today's session a very vibrant, wonderful and successful. Thank you once again. And I request all to kindly join us for photo session, then kindly proceed to banquet hall for lunch. Thank you all.
How the session for